Welcome to the Tailor Law Podcast, where we discuss family and divorce law topics to help you navigate life's most important decisions. I'm your host, Deepa Taylor, and today we're exploring a subject that often stirs up mixed emotions and misconceptions: the potential risks of prenuptial agreements in Ontario. Prenuptial agreements, or prenups, are often seen as a practical step for couples planning to marry. In Ontario, these agreements are formally known as marriage contracts. They allow couples to outline how assets and debts will be divided in the event of a separation or divorce. While prenups can provide clarity and protection, they also carry certain risks that couples should carefully consider. One significant risk is the possibility of the agreement being challenged in court. In Ontario, the Family Law Act governs prenuptial agreements, and courts have the authority to set aside a marriage contract if it was signed under duress, undue influence, or without proper financial disclosure. For example, if one party felt pressured to sign the agreement shortly before the wedding, or if significant assets were hidden, the agreement might not hold up in court. This highlights the importance of full and honest financial disclosure and allowing ample time for both parties to review the contract. Another risk involves the fairness of the agreement. While Ontario law allows couples to customize their marriage contracts, the terms must be reasonable and not unconscionable. If a prenup heavily favors one spouse or leaves the other in a financially vulnerable position, a judge may deem it unfair and invalidate parts of the agreement. This is especially true if circumstances change significantly over time, such as the birth of children or a drastic shift in income. Independent legal advice is crucial when drafting a prenuptial agreement. Without it, the agreement may be more susceptible to legal challenges. Each party should consult their own lawyer to ensure they fully understand their rights and the implications of the contract. This step not only strengthens the enforceability of the agreement, but also promotes fairness and transparency. It's also important to recognize that certain matters cannot be addressed in a prenuptial agreement. For instance, custody and access arrangements for children cannot be predetermined in a marriage contract. These decisions are always made based on the child's best interests at the time of separation or divorce. Attempting to include such provisions could lead to complications and potential challenges to the agreement. Additionally, life circumstances can change in ways that a prenuptial agreement cannot always anticipate. For example, one spouse might become ill, or a couple might experience significant financial shifts. Without provisions that account for these possibilities, the agreement may become outdated or inequitable. Periodically reviewing and updating the agreement can help mitigate this risk. Finally, the emotional impact of discussing and signing a prenuptial agreement shouldn't be underestimated. Conversations about dividing assets and preparing for potential separation can create tension and mistrust between partners. Open, honest communication and mutual respect are essential to navigating this process in a healthy way. Prenuptial agreements can be valuable tools for protecting individual interests and setting clear expectations, but they are not without risks. It's essential to approach them thoughtfully, with the guidance of experienced legal professionals. At Tailor Law, we understand the complexities of family and divorce law in Ontario. Our dedicated team is here to help you make informed decisions about prenuptial agreements and other legal matters. If you're considering a prenup or have questions about your legal options, visit us at tailorlaw.com to schedule a consultation. Thank you for tuning in to the Tailor Law Podcast. Stay informed, stay empowered, and remember that we're here to support you every step of the way.